Adjournment request, if any, from item number 1 to 6.
Lordship, I have to mention item number 1, Lordship.
Number one,
Yes, Lordship.
on which they have
Lordship, petition appellant, Lordship, extending until apex bank, Lordship. So in this case, Lordship, on AG will appear in this case.
I take.
Bless you.
27 October.
May I please read the Lordships? Lordship, I beg to mention item number 7. Lordship, with the consent of the other side, I pray for an adjournment.
7 and 8.
7.
7 and 8.
7 and 8.
Yes, thank.
Yes, Sir Lordship, as Senior Advocate Mr. King. Sir.
Lord, actually, I'll be addressing the lordships in this case. Yes, my lord. My lord, next week. Actually,
it goes only in November. Chaudhary for covered matter.
not covered.
But privatization is over.
My lord, here we have raised an issue which was not considered by, that was a case where state of Kerala itself was a party to the tender process. It was in that context that judgment was rendered. Here we are challenging the policy itself, my lord.
Of privatizing.
No, not per se, but whether the airside part of the airport can be, let out to private parties, because section 12 of the act is very clear.
No, they're out of operation. Other people.
No, my lord, no,
That
no.
cannot happen. So it's only the running the management.
Not management, everything has been let out, my lord. That's the whole difficulty. Yes.
Sometimes in November.
I
Yes.
beg to differ on the senior councillors, that we have also filed our affidavit to that.
Yes, yes.
Yet to be
Yes, yes, no.
as joint break for. We have the part. This. Oh, but
4th of November.
Deep.
this is the airport at Port for.
This Guwahati airport, my lord. We are, yeah.
Why Port for?
Borjhar, the name of the place, my lord. Okay. My lord, by spending 8,000 crore, Government of India is spending to build that new terminal building. And it will be given on a platter to Adanis.
To show the package also, perhaps Bombay Airport also.
Yes, Bombay was the first. Bombay and Hyderabad were the first.
It's not this.
No, my lord, we will confine our argument only to violation of the Airport Authority of India's Act. That's all. Nothing beyond that.
From item number 9 to 13, adjournment request.
May I please the lordship? May I please the lordship? With the consent of the other side, I beg to mention item number 10, lordship. Mr. KL had some personal difficulty, lordship. So matter may be taken after vacation.
That's the form. Remember.
Okay. 6th November.
Highly hope. May I please your lordship? Lordship, with the consent of the other side, I beg to mention item number 45 and 46. Lordship.
Last. Yes.
45
45
and
and
46. Lordship.
Six 11. Any other request? Daily list for admission item 2.
May it please the lord. So, my lord,
challenging that verifiers of the notification that was issued by the then, my lord, that is at 68. My lord. My lord. Merit. In exercise of the power conferred under Article 229 of the Constitution, Honorable the Chief Justice acting has been pleased to make the following amendments in the Guwahati High Court Appointment Conditions of Service of and Conduct Rules 1967 with immediate effect. The following sub-rule is added as sub-rule 4 under Rule 7, Gazetted Officers. The post of the court officer in the principal seat of the Guwahati High Court and the Kohima bench shall be filled up by calling options from the administrative officer judicial and the senior judicial assistants. The persons appointed in the post of the court officer shall maintain their respective seniority in their original cadre, that is the cadre of administrative officer, judicial or senior judicial assistant, and their further promotion will be considered on that basis. We are concerning with this only. Now, my lord, this petition has been filed only under 3 or 4 grounds. First of all, Rule 7(4) already exists. That is a different things. This perhaps the numbering of the rule is wrong. It should have been something else, Rule 7(5) or something like that. Existing Rule 7(4) is something else, my lord. I have quoted it here. My lord may have this book, my lord. Is there? I go to. I quoted also in the petition. Page 639.
This. If it were only the wrong numbering or wrong placement, perhaps it would not have.
No, not only that, my
It would
lord.
not have led to so much of discussion. Let's see what is that rule.
Had it been so, my lord, I would not have filed the challenge list, my lord. There are 2 more grounds. I'm coming. I'm coming. My lord. Lordship may kindly come to page 639.
6
39.
of this book.
Yes, yes.
639, yes.
Rule 7, Gazetted Officers. Next page, my lord. Then, my lord, will kindly come to page 643. 643, my lord. Sub-rule 4. This is the sub-rule 4 of existing sub-rule 4 of Rule 7. The post of chief translator and senior grade translator as mentioned above so and so. This is something else. So apparently, my lord, this is a wrong numbering. Though it is ministerial call, but until and unless this is amended, this cannot be given effect to. This amendment by the page 68 cannot be given effect until and unless this is corrected. 1. 2, my lord.
No, first come to B also. At page 68 of your brief, the following sub-rule is added as 4A. The post of court officer in ISO. Acha, this is with respect.
This is different, my lord.
Should I? Alright, so this is one ground.
Wow. For a moment, if you presume that this is a ministerial mistake, that can be corrected. But until and unless it is amended by a proper notification under this authority of the Honorable Chief Justice, this cannot be given effect to. 1. Number 2, post of court officer is a promotional post, is a higher cadet. A person, after following a due process of law, selection process, of going through a selection process, if he is posted in a substantive post, in a substantive manner.
No, you'll have to show the rules. Take us to the rules, because normally court officer, there is no feeder cadre for the court officer in other high courts.
But here it
We'll
is.
talk about, we'll see the High Court of Assam rules.
Yes.
The post could be given to anybody. He is one person, one post in the High Court of the court officer. But he maintains his seniority from the cadre from where he is lifted. So many a times, a very senior officer, very senior ranking officer in the administrative department is given that post. Many a times it is junior officer. It depends upon the discretion of the Chief Justice and his performance. So normally the seniority inter C is maintained in the cadre from where he has come. So let us see the rules of the assembly.
Yes, my lord. But in Assam, my lord, if lordship comes to 664 of that book, my lord,
6.
page 664. It's a cadre post, my lord. Page 665, class 2C. 665. This is the schedule.
Hmm.
This is class 2C,
That's right.
Roman 3.
Hmm.
So it's a cadre post. And this post carries a
Therefore, this cadre includes administrative officer judicial.
pardon, my lord.
It includes class 2C post includes administrative officer judicial also.
There are many posts. In class 2C, there are many posts. But all are cadre posts. Here, the post of assistant register, this class 2C is the feeder cadre for the post of assistant register.
For the post of?
Assistant register, ministerial stream.
And that's right.
Then, my lord, when this poster under class 2C, this poster cadre post, and if I get promotion from SJ, senior judicial assistant to court officer,
No. It's following options from administrative officer judicial and the senior judicial assistant. Senior judicial assistants come in which cadre?
senior judicial assistant is in the,
It's in class 3A.
yes, my lord. It's 3A, it's a lower cadre. So once I got the promotion,
And this concerns the person. I mean, you just can't challenge the rules in void. So who is this person who has challenged this?
but I'm the court officer at
You
present.
are the court officer.
Yes.
You came from the cadre, you came from administrative officer judicial or from senior judicial?
Senior judicial assistant, I was appointed as a court officer.
So therefore, right. Okay. How is a court officer appointed?
Calling options from the senior judicial assistant.
Either cadre, but they keep with the cadre. They would invite the applications of senior judicial assistant. That- Where is the judgment? If in case of another employee of this court, perhaps the matter, you appear for the high court.
Yes, my lord, on last occasion,
Is there?
Last occasion, give it today.
My lord,
Is there in the book? Yes, Neeraj Sharma judgment, that is, I have given the book. GLT.
Darul Islam. Yes.
Millard, I will come to the judgments later if I can show the facts.
All right.
My lord, after this, my lord, this issue was placed before the, by the Honorable Chief Justice in earlier occasion. The same applications given by this person was placed before a judges committee. And the opinion of the judges committee is on record. May I show this now?
Yes.
This will clarify certain issues.
All right.
If lordship can come to page 74.
Yeah.
My lord, this is the, page 73 is the starting page, my lord.
Yes.
This is the constitution of the judges committee at page 73.
Hmm.
My lord, 5 judges committee, my lord.
That's all right.
My lord,
Consider it.
next page is the point number 4. consideration of the representation of Shri Zahirul Islam, Court Officer 1 of this registry for regularizing him in the post of court officer by fixing his seniority with effect from the date of joining, that is 18/8/2016. The committee, after a threadbare discussion, resolves to request Honorable Mr. Justice Suman Sham and Mr. Justice Manish Chaudhary to examine the matter along with other collateral issues. Now, their examination is at page 78. Agenda, consideration of the representation dated so-and-so submitted by so-and-so, praying for regularizing his service in the
That's
post.
right. Read second paragraph of the resolution.
Yes, as per Rule 7(4) of the Guwahati High Court Service Rule 1967, the post of court officer is required to be filled up by calling options from the administrative officer, judicial and senior judicial assistants. It appears that as per the requirement of Rule 7(4), the candidature of Shri Zahirul Islam, along with a number of other candidates belonging to the cadre of administrative officer, judicial and senior judicial assistant, were considered on the basis of options called for by the registry for filling up of the post of court officer number 1. At that point of time, the applicant was serving as junior judicial assistant. All the applicants were then subjected to a proper selection process, which included oral interview, whereafter the applicant Sri Zahirul Islam was selected and recommended for appointment as court officer number 1. Since his appointment as such, the applicant has been serving as court officer number 1. The non-applicant Sri Hengomang Lojem is holding the post of court officer number 2, but he has not made any prayer for regularizing his service or for fixing his seniority. In order to examine the validity of the prayer made by the applicant, this committee has gone through the relevant rules, circulars, notification, as well as the resolution adopted by the various committees from time to time, preparing to appointment of court officer, pertaining to appointment of court officer, and finds that conditions of service of the employees of the Guwahati High Court Registry is governed by the Guwahati High Court Service Rule 1967, framed by the Honorable Chief Justice in exercise of the power under Article 229 of the Constitution. The post of the court officer was originally an ex-cadre post, and the name used to be filled up by adopting various temporary measures, including calling options from ex-army paramilitary officers. Subsequently, the post of court officer number 1 was made a cadre post by amending the Schedule 1 of the rules of 1967, and one post of court officer was incorporated as Class 2C in Schedule 1 of the rules. Although originally only one post of the court officer was encadred, yet subsequently by issuing notification dated 24/7/15, the second post of court officer was also encadred. Schedule 1 of the rules of 1967 lays down the grade pay and cadre of the post coming under the High Court services. As per the amended Schedule 1 of the Rule 2, post of court officer are included in the Class 2C cadre. The other posts forming part of Class 2C service of Schedule 1, along with their revised pay bands and number of posts as on date, are indicated herein below for ready reference. This is the table. Thereafter, my lord, from a careful examination of the rule of 1967, more particularly the post included in Class 2C, we find that the post of administrative officer, judicial, court officer, and protocol officer belong to the same cadre, that is Class 2C. It also prima facie appears that all the three posts incorporated in Class 2C carry identical pay scale and are interchangeable in nature, and the materials placed before the committee suggest that the registry has also, from time to time, understood the rules in such a manner. Therefore, going by the edict of the rules, it is apparent that all the posts included in Class 2C constitute a composite cadre. However, the same cannot be said for the post of senior judicial assistant, which post apparently is not a part of Class 2C cadre. The post of SA apparently belongs to a different cadre under the rules of 1967. This is the crux, my lord. It is settled principle in service jurisprudence that inter-se seniority of employees ought to be determined in respect of those candidates who belongs to the same cadre. Therefore, the seniority of the employees occupying any of the aforementioned posts of Class 2C, including the applicant, will have to be determined inter se, the incumbents holding the various posts in Class 2C cadre and not in the cadre of SJA, which is not Class 2C post. However, Such a recourse would not be permissible in this case in view of the Rule 7(4) of the Rules of 1967, which provides as follows. This is the rule quoted under, which is now under challenge before your Lord. We have also noticed that the appointment of the applicant in the post of court officer was made against a substantive vacancy in respect of a post belonging to class 2C based on a proper selection process. As such, we are of the view that there is no scope for reversion of the applicant to the previously held post of senior judicial assistant. If that be so, no meaningful purpose would be served by maintaining the seniority of the applicant in the original cadre of senior judicial assistant. More so, since the Rule 1967 do not envisage any provision of reversion of an incumbent holding a class 2C category post to another cadre. However, in view of Rule 7(4), the seniority of the applicant will have to be maintained in the senior cadre, in the cadre of senior judicial assistant only. That is the cadre he originally belonged to. This, in the considered opinion of this committee, has given rise to an anomalous situation which cannot be resolved until such time the Rule 7(4) is suitably amended. In the light of the above observation, this committee therefore recommends that the matter be placed before the appropriate authority for consideration as to whether Rule 1967, more particularly Rule 7(4), requires amendment. In doing so, it may also be considered as to whether the rules should be amended so as to provide more clarity as regards the promotional avenues for the incumbents holding class 2C category post by laying down the feeder cadre and the mode of selection in respect thereof. Now, my lord, this was placed before the main committee in the next page, page 83, which has been accepted by the 5 judges committee, and the then Honorable Chief Justice has, in page 88, my lord, accepted this recommendation.
Then necessary thing was not made.
Thereafter also, my lord, the amendment was not made. That is why this petition.
And what is this judgment?
With lordship, this division bench judgment. This is in the GLT. This is, my lord, this part of this issue was
No,
raised
the
even.
single judge's judgment, WPC number 2755.
Yes.
By
That is there.
by the same person.
Yes, by the same part.
This was on which issue?
That is, my lord, I was not given the scope to appear before the post of, for the interview for the post of assistant registrar, even after I am holding a substantive post in.
What was held here?
Here it is, my lord,
Page 54, man.
Page?
54, man. His grievances has been adjustment. Para 66. Is that going to mean for the what
well, page paragraph 66, Roman 3, Miller. It also follows the recommendation of the judges committee.
Was this challenged?
No, it is not challenged by anyone.
But where is it pinching you now for you to have come here? This puts you in the category of.
No, my lord, in my respectful submission, my lord, perhaps the single judge's order takes care of my grievance. But this petition was filed while this petition, the first petition was pending, the second petition.
No, which is first and which is second? Now,
The
this-
judgment that has been rendered is first,
Hmm.
and this one is second. Now, my lord, what I respectfully submit, my lord, even if for the academic purpose or for the purpose of rectifying the rules that is in place now, my lord, perhaps lordship may decide in judicial side.
Not necessary. Not necessary, considering the recommendation of the committee, this goes before the Chief Justice in the administrative side who would pass
It
necessary.
is accepted, my lord, it's on record. Page 88, my lord.
That's all right. So therefore, there will be amendment to the rules.
But if lordship says that in this petition, while disposing of this petition, lordship says that the already a decision has been taken, but not forthcoming by way of an amendment. That is why this petition, my lord.
Which page is the court officer in this book?
Pardon, my lord.
In this book, page 641. Very difficult. Rules for part 2, rules for appointment, and in the classification is in section 3, then section. Let us come to section 7. Wait with it. Yeah, wait with that. 7. Very good. Yes. We have heard. Mr.
Well,
We have heard. We have heard Mr. Chamur
yes, my lord.
for the petitioner and Mr.
G.
G. Vaishya, learned advocate for the High Court. A challenge has been thrown by the petitioner with respect to the provisions contained in Rule 7, bracket 4 of the Guwahati High Court bracket appointment, conditions of service and conduct rules 1967. The rule reads as hereunder. Within court, the posts of court officer in the principal seat of the Guwahati High Court and the Kohima bench shall be filled up by calling options from the administrative officer judicial and the senior judicial assistant. The persons so appointed in the posts of court officer shall maintain their respective seniority in their original cadre, that is in the cadre of administrative officer bracket judicial / senior judicial assistant, and their further promotion will be considered on that basis. The challenge is on several grounds. The first be that the numbering of the rule as amended in exercise of powers conferred under Article 229 of the Constitution of India to the Chief Justice, to the then Chief Justice. What have I, what it is, right? The Rule 7, the original Rule 7, Sub Rule 4 is for a different purpose. It deals with a different class of post. At best, the amendment should have been made as 7(4) A or B for it to be implemented effectively. The other challenges with respect to the condition in the rule that any person appointed on the post of court officer, for which the feeder post would be administrative officer judicial and senior judicial assistant, would be required to maintain his respective seniority in the original cadre, that is either in the cadre of administrative officer judicial or senior judicial assistant, and that the promotion thereafter shall be considered on that basis. With reference to the schedule, the learned counsel for the petitioner has drawn the attention of this court to the fact that an administrative officer judicial and a court officer fall in the same class of employee, that is under class 2C, whereas a senior judicial assistant, which would include an accountant or editor paper book or cashier, falls in class 3A, which is a junior post. A bare reading of the rule, a bare reading of section 7(4) as it stands today indicates that the post of a court officer is required to be filled up by calling options from either administrative officer judicial or senior judicial assistant who make for different class of officers. In the present case, the petitioner belonged to the cadre of administrative officer judicial, that is the same class in which the court officer's post has been placed. His application was considered, and after proper selection process, he was appointed as the court officer 1. There are 2 posts of court officers earmarked. The issue had come up for consideration the issue with respect to seniority, issue with respect to inter-C seniority of such court officer was concerned, was considered, the issue came up for consideration before the administrative side of the High Court. The consideration, in the consideration, the issues which were factored in were that the post of court officer originally was an ex-cadre post, which could have been filled up as a temporary measure from persons not particularly belonging to High Court service. But later, the post of court officer was encadred in class 2C post of the High Court. The Schedule 1 of Rules of 1967 lays down the grade pay and the cadre of the posts coming under High Court services. As noted above, 2 posts of court officers are included in class 2 bracket C cadre. The other posts in class 2C are administrative officer judicial and protocol officer. It is thus to be noted that the post of administrative officer judicial and the court officer, as also the protocol officer, is considered to belongs to the same cadre, that is class 2C. Even otherwise, it would be apparent that all the 3 posts referred to above in the same cadre carry identical pay scale, and therefore these posts could be interchangeable. However, the post of senior judicial assistant, which is not a class 2C post, but a class 3 bracket A post, has also been considered to be the either post for appointment of court officer, for promotion of court officer, for promotion to court officer, for appointment and promotion to the post of court officer. There is no interdict on the principle in service jurisprudence that inter-C seniority of employees is to be considered amongst candidates who belong to the same cadre. Hence, a court officer's seniority will have to be maintained, it has been argued on behalf of the petitioner, along with the incumbents holding various posts in clause 2C namely administrative officer, judicial, and protocol officer, apart from the post of court officer. The question which has been raised is whether such seniority could be maintained of a court officer who gets selected from the feeder post of senior judicial assistant, which, as noted above, is an inferior post falling in class 3. The rules which are under challenge, however, does not address the aforementioned issue, and according to the rule as it stands today, the court officer appointed from the post of senior judicial assistant would, in the seniority list, would be required to maintain his seniority in the original cadre, that is of the senior judicial assistant, which is not a class 2C post. With respect to the petitioner, who before being appointed as court officer was an administrative officer judicial, the issue would not be very relevant. However, for a court officer who is appointed from the post of administrative officer, senior judicial assistant, the rule would not be jurisprudentially correct, jurisprudentially sustainable. Especially in view of the fact that an applicant for the post of court officer is considered against a substantive vacancy in the post belonging to class 2C, and the appointment is based on a proper selection process after interview and other tests. The committee, the judges committee, about which reference has been made earlier, had also noticed that there is no provision in the rule for reversion of a court officer to a class of post which is inferior to the post of court officer. In that scenario, asking a court officer who is appointed from the post of senior judicial assistant to maintain his seniority in his cadre would be rendering the very concept of inter-C seniority meaningless. Meaningless. It was thus suggested by the Committee of Judges that Rule 7.4, which is under challenge in the present petition, ought to be amended. It further appears, during the course of argument, it was further brought to our notice that this petitioner, when was denied the opportunity, when was denied the option of, when was denied the denied promotion to the post of assistant registrar from a superior post to that of the court officer. He had approached this court by WPC number 2755 of 2024, in which it was held that a court officer belonging to class 2C of schedule 1 to the rules of 1967 has a right to be considered for promotion to the post of assistant registrar, and that the rider attached to the appointment letter, as also the appointment letter of the petitioner, as also the provision contained in the second part of Rule 7.4 of the 1967 rule, would not affect the right of such court officer, and in this case the petitioner, to be considered for promotion to the post of assistant registrar (ministerial stream). If the same would not have been done, the further promotion or appointments to different posts on the basis of either seniority come merit or merit come seniority cannot be effected / implemented in a proper manner. However, in the present case, we do not find the petitioner to be inconvenienced on any account whatsoever, as he has been permitted to be considered for being promoted to the post of assistant registrar, thereby considering his seniority in accordance with the principle of inter-se seniority amongst the same cadre following in a particular class of posts. However, the rules are required to be changed / amended to make it more implementable and meaningful as well. We therefore eschew from deciding this case in the judicial side and close this petition, but with the direction to the registry to place this case before the Chief Justice in his administrative side for making suitable amendments in the rules in the 1967 rule with respect to the correct numbering of the rules and necessary modification with respect to the seniority of the court officer. The petition stands before.
Lovely.
Yes.
Item 3 and 4.
My learned friend petition.
My lord, here two petitions are being tagged together. The first, item number 4, your lordship, that was earlier in time. There, our prayer before the learned single judge was that action should be taken against the private respondent in terms of the judgment rendered in Kumari Madhuri Patil for acquiring a false caste certificate.
That's a very vague way of addressing the court. Let's see what the matter is, what has been decided. You straight away come to the middle of the.
No, I was just.
He has a right to argue.
Of course.
If he fails in his duty, he will ask.
Of course. I'm sure my learned friend will not
we completely do that
Yes.
justice. We
Yeah.
are very short.
Item number.
And in the second one, your lordship, which is the first item, there perhaps that issue has to be decided first because that petition was filed by the other side.
Tell us what is the issue,
Yes,
which
yes.
are these matters,
Yes.
what is the matter about?
Very well,
Don't be under the presumption that we know the facts.
very well, very well. I'll start from the very beginning then, your lordship,
Right.
then perhaps that will be better. So what had happened, your lordship?
Which appeal are you?
Lordship, I'll start
you
with
want us to take up?
item number 3 here.
Number 3,
Yes, WA 5,
please.
Writ appeal 5, your lordship. So if I may take your lordship to the facts first.
Yes.
So initially, your lordship, an FIR was registered by the private respondent.
Who are the private respondents here?
The private respondents here, your lordship, are,
We have no idea about the case. You have to argue
Yes,
it
sir.
afresh.
yes, your lordship.
Hmm.
The respond number 2 and 3, your lordship. The respond number 3 is the mother of the respond number 2.
Yeah.
He had lodged an FIR against the appellant before your lordship on allegations that he had committed an offense under the POCSO, your lordship. So when that FIR was under investigation, your lordship, the matter was transferred to the CID.
Your senior has come.
Yeah, fine.
Mr. Chaudhary, tell us the facts straight away
Yes.
with reference to the writ petition.
Yes.
Appeal reference, we'll see it later.
Lord, the story goes like this, or rather the facts goes like this. The appellant before lordship is an IPS officer.
Right.
And respondent number 3, she is a state police service officer. At one point of time,
So then again, your reference is by the appeal.
yes,
But we don't have the memo of appeal yet. Where is it?
the writ appeal number, my lord, 5 of 2025. The subject matter of challenge is a caste certificate.
The appeal. Anyway, you tell us with reference to the writ petition.
No, basically, my lord,
Take
the
the names.
issue was a my lord caste certificate.
Issue was a caste set.
Yes.
Yes.
The deputy commissioner's office issued a caste certificate in the name of appellant number, respondent number 2, which was put to challenge my lord. Eventually, matter was referred to state level scrutiny committee. State level scrutiny committee, my lord, interfered with this caste certificate on the ground that she cannot claim caste certificate because the ratio laid down in the Ramesh Bhai Dabhai doesn't apply. So that is the case. Now, my lord, the learned single judge has overturned the findings of the scrutiny committee on the ground that affinity tests would override everything else.
Which test? Affinity test.
Yes,
Let us come to that part of the.
yes. Please come to the judgment, my lord. I don't think it will take any longish time. Now, please come to my lord, page number 584 in volume 2.
Now, give me the internal page of the judgment.
Internal page is 49,
Volume
para 53.
Yes.
From the above quoted paragraph in case of Ramesh Bhai Dabhai, it would be seen that in an intercaste marriage or a marriage between a tribal and non-tribal, the determination of caste of the offspring is essentially a question of fact to be decided on the basis of the facts adduced in each case. There may be a presumption that the child has taken the caste of the father, and the presumption may be stronger in the case where intercaste marriage or marriage between a tribal and non-tribal, the husband belongs to a forward caste. But by no means the presumption is conclusive or rebuttable. But this is nothing but reiteration of para 54 of Ramesh Bhai Dabhai. Now please come to para 44, Miller. From the above conclusion of the Supreme Court, what is required to be shown and proved in the case of offspring of a forward caste father and scheduled tribe mother are: the offspring was brought up by mother who belongs to the scheduled tribe community. The offspring being born to a forward caste father, the offspring did not have any advantageous start in life. On the contrary, suffered the deprivation, indignities, humilities, and handicap like any other member of the community to which his mother belonged. The offspring was always treated as a member of the community to which her mother belonged, not only by that community, by the people outside the community as well, meaning thereby that the offspring is identified with the mother's community and the father. So these are the three propositions which was called out by the learned single judge, my lord.
No, these are based on decisions of the.
No, this was the conclusion of the learned single judge, relying on the Supreme Court judgment.
Supreme Court judgment.
So my humble submission is, my lord, the proposition A is not correct, subject to what your lordship may say.
What?
Offspring was brought up by mother who belongs to scheduled tribe community. That is never a test, my lord. Yes, B and C are. Now, my lord,
No.
let us
See, just a minute. Now, one is very deeply integrated in DNC.
yes.
Because
Okay.
if
Let-
one
let-
is
let-
if one is found to be correct, one is found to be true
Yes.
in case of the child.
Yes.
If he has been brought up by
In
a
fact-
scheduled tribe
In
mother.
fact, my lord, the learned single judge, in arriving at the impugned conclusion, relied upon the decision of the Supreme Court in Indrasoni, para 779.
Sony comes later.
No, Indrasoni has been relied upon by the learned single judge.
May have
Yes.
been, but
No.
these
Okay.
options,
Okay.
these tests,
With regard to this
these
test,
parameters also have been decided. No,
yes.
these parameters have been
Now
decided.
let us see, my lord, whether
This is
these
Ramesh Bhai.
parameters were
One second.
considered by this.
Let us go step by step,
Yes.
Mr. Chaudhary.
Yes.
Ramesh Bhai, Dada Bhai, Naika,
Hmm.
these are the parameters on which it is to be
Yes.
tested. Now, saying one is wrong, we can't.
Anyway,
Supreme
let us not go to
Let
that.
us not.
Yes.
All.
Now, my lord,
And it is otherwise innocuous, no?
it is innocuous,
Yeah.
and my humble submission is, my lord, state level scrutiny committee did apply their mind to these relevant factors. I'll straight away bring your lordships to that.
So, just a minute.
Huh.
The offspring being born, and these are three things. And
Yes.
what is the court to say about it? These are the conclusions.
Yes.
Now, let us see paragraph 50.
In the present facts, it would be seen that the petitioner number 1, along with her brother, was raised by the mother solely who admittedly belonged to scheduled tribe community since their ages at 6 and 2 when their father had expired.
Hmm.
The vigilance report does not in any manner state that the petitioner number 1, along with her brother, were living with her paternal grandparents. On the other hand, the report categorically mentions that both the children of petitioner number 2 had been raised by the petitioner number 2. Under such circumstances, the first condition of test laid down in Ramesh Bhai is met. Let this court now take up the second criteria to be satisfied. In the earlier segments of the judgment, this court had extensively dealt with deprivation, discrimination, indignities, humilities, and handicaps faced by the backward disadvantaged classes. This court had dealt with the socio-cultural disadvantages faced by citizens belonging to disadvantaged backward classes, which is on account of inequalities and deprivation faced by them since centuries. Therefore, deprivation and discrimination fell. The indignities and humiliation faced and handicaps on account thereof are ingrained. This is in my humble submission. I'll come to this. In the characteristics of backward disadvantaged classes, in the said backdrop, if a child, as in the instant case, is brought up in such an environment and community which had already suffered and is suffering the deprivation, humiliation, indignities, and handicap, the child would automatically be enduring the deprivation, humilities, and indignation and handicap. To substantiate the above proposition, let this court take the reverse analogy. What would be the status of a child born to a scheduled tribe father and a forward class mother, where a father expired when the children were 6 and 2 respectively, and mother had raised and in raising the children in a forward class environment? In such a situation, the children would have an advantage being brought up in a forward class environment wherein deprivation, humilities, dignities, and handicaps are not felt.
Another paragraph 57 now.
Yes. So and so.
Moving forward.
Yes.
Paragraph 57.
Yes. Moving forward, a question arises whether the petitioner number 1, along with, before that, if your lordship would kindly permit me to read this up at page 587. Therefore, the above analysis would show two very pertinent aspects. First, when a child is brought up in an environment and community of scheduled caste, scheduled tribe, from a tender age, the very nurturing and raising of the child in such an environment and community would ingrain upon the child the characteristics of scheduled caste, scheduled tribe, as observed by the Supreme Court in paragraph 779 of Indraswamy. I'll paste this. Secondly, a child having been brought up in an environment of a forward caste would have the advantage to reap the benefit of economic and socio-cultural advantages which forward class of citizens have been enjoying and enjoyed. Moving forward, the question arises as to whether petitioner number 1, along with the brother, had any advantageous start in the life, being born in the family where father belonged to other backward classes and not scheduled tribe. The answer has to be negative in the present facts, inasmuch as the very nascent age of 6 and 2 respectively, they have only under custody and care of the mother. It is also pertinent to note that if the children of petitioner number 2 were not brought up in an environment of their father, then in what type of environment children were brought up? Inasmuch as children have to be brought out in some environment. Petitioner number 2, admittedly having been raising the children on her own. The natural corollary, therefore, is that children are brought up in an environment of a community of her mother who belongs to scheduled tribe. So, my lord, the analogy which the Honorable Single Judge has taken is irrespective of what the father is, whether he belongs to forward class or backward class, everything would depend upon the environment in which he and she is being born and brought up. Well, I don't think that's the proposition the Supreme Court has laid down in any case. On the contrary, my lord, there was a full bench judgment of the Bombay High Court, which went to Supreme Court. In Supreme Court, there was division. Then, my lord, eventually the matter was referred to 3 honorable judges. And Justice Oak had delivered the judgment where it says, my lord, this is not the litmus test. It all depends upon the facts of each case. But along with that, if there are other factors which help the cause, then only it can be treated as. Now, my lord, kindly see, my lord, in Ramesh Bhai Dabhai, the Honorable Supreme Court has said that if a child born out of an intercaste marriage is born, the presumption is he will take the father's caste, he or she. But that presumption is not, my lord, foolproof. It all depends upon the facts of each case. Now, in the present case, my lord, this respondent number 2, the daughter of respondent number 3, my lord, while she was admitted to the school, she has declared a general caste. In school level, everywhere, my lord. Now, when this criminal proceeding came up, my lord, just to rope in that 89 Act of SC and ST, she started developing this trend. Now, kindly see, my lord, how the mother is also guilty. Please come to page number 242. This all started with this application.
No, finally, before that,
Yes.
that.
Yes.
Finally, what has the single judge done?
Yes. Now, single judge has interfered with the, my lord, the
Finding
order of the state
finding
level
of the
scrutiny committee
Huh.
and referred the matter back at page 604, internal page 70. And my lord, it's not that everything was kept open, but the
Let us see paragraph
para 78.
Para
This court
70
is therefore
para
of the,
77,
okay,
just to start.
yes. The impugn order bearing dated 24/9/21 passed by the SLS is set aside and quashed. Petitioner have been able to substantiate the following criteria laid down in Ramesh Bhai Dabhai, Naika. Petitioners have been able to show and prove that petitioner number 1 and the brother have been under the care and custody of petitioner number 2. Petitioners have been able to prove that petitioner number 1 as well as her brother did not get any advantageous start in their life, being an offspring of an OBC father and scheduled tribe mother. Petitioner number 1 as well as brother having been raised and nurtured since their age of 6 and 2 respectively in community of the mother have automatically suffered the deprivation, indignities, humiliation and handicap which the petitioner number 2's communities have suffered and is still suffering till date. Petitioners have been able to prove that the community of the petitioner number 2 had accepted the petitioner number 1 and their brother as a member of the community of the petitioner number 2. The community of the petitioner number 2 have also identified petitioner number 1 as well as their brother as member of the petitioner number 2's missing community. The aspect as to whether petitioner 1 as well as her brother have been accepted by other people outside the community of petitioner number 2 as belonging to ST community of the mother is not clear from the record. The reason being the inquiry officer, while submitting the vigilance report, did not take into consideration the relevant aspect while purportedly making inquiry with persons of locality wherein petitioner number 1 and her brother have been raised. It is also seen that the vigilance report being furnished to the petitioner number 2, she could have provided necessary evidence in respect of proof and the said aspect as to whether people other than the people of the community of the petitioner number 2 have identified the petitioner number 1 and the child as belonging to petitioner number 2's community. The court is therefore of the opinion that matter requests to be remanded back to the SLSC to decide only on the aspect as to whether people outside community of the petitioner number 2 have also identified petitioner number 1 as well as brother as belonging to petitioner. Only this much was left. The court further grants liberty to the SLSC to call for another fresh report on the above aspect, which have been directed to be considered, that is whether people outside the community of petitioner number 2 have also identified petitioner number 1 as well as brother as belonging to petitioner number 2's community or that of their father's community upon such report being furnished. And if such report goes against the petitioners be issued a show cause notice along with the said report. It is further observed and directed that in the circumstances such show cause notice and report is furnished, the petitioners herein would be at liberty to file reply and also adduce such evidence and deemed free. Petitioner also afforded in such an opportunity of hearing. The said exercise be completed by SLSC within 45 days. There is a stay on this part of the judgment in this retake. Now, my lord, the learned single judge has called out a procedure.
The SLSC had decided that no.
No, your lordship will kindly come to the SLSC part, my lord.
Yes.
Yes. Volume 1, page 57, my lord. The operative portion, my lord, which is relevant, is at page 59. I do not know, my lord, how the learned single judge could have substituted this finding. In fact, on the teeth of the proposition laid down, this was the test. Please come to page 59, the second subpara. First subpara, after careful perusal and examination of all records, personal hearing of Srimati Lina Dole, mother of Mrs. M.S. Dibyana A. Lahan and Gaurav Upadhyay, and analysis of the evidence and observations, the state-level scrutiny committee finds as under. Although M.S. Dibyana A. Lahan is the offspring of a marriage between tribal Lina Dole and non-tribal Nilutpal Lahan, and she has been brought up by her mother Lina Dole, there is no evidence that Dibyana A. Lahan suffered disabilities, social, economical, and educational cumulatively. Since Lina Dole is an APS officer belonging to class 1 cadre in the government of Assam, she has provided good educational facilities to her daughter in a reputed school of the state. The statements provided by members of the missing community, that is Korneshwar Dole, President All Guwahati Missing Kebang, and Ranjit Kumar Dole, which are available on record, merely state that the children of Srimati Lina Dole belong to missing community, and said statements do not substantiate anything regarding their tribal custom, way of life of the children, or that children of Srimati Lina Dole suffered disadvantages or disability due to their mother's ST status. On the contrary, the vigilance report found that Srimati Lina Dole belongs to Miri missing community and originally hails from North Kikunpur district, and she had only little connection linked with the people of her native village. The available evidence suggests good education and amenities were made available and accessible to Dibya Lahan, and that condition that by virtue of being daughter of a forward class father, she did not have any advantage start in life, but on the contrary suffered the deprivation, indignities, humilities, and handicap like any other member of the community to which her mother belonged, is not fulfilled in her case. Accordingly, the state level scrutiny committee is of the view that Dibyana A. Lahan, daughter of so-and-so, does not belong to scheduled tribe community of the state. Now, my lord, every conceivable relevant considerations which Honorable Supreme Court has mandated has been applied and the finding has been recorded. Now, the Honorable Single Judge's only view, as my lord, that affinity test is the only test.
You will bear with me. Mr. Chaudhary, tell us one. The report has been quashed, this aggrieves you.
Yes.
What is the purpose of, what is the reason why you are aggrieved with respect to
My lord, I am
non-giving or giving?
no,
of the
I am
task?
aggrieved.
That-
I am aggrieved because, my lord, they have invoked that SC/ST provision in my criminal case pending against me.
Therefore, the purpose or challenge is different.
Yes.
Right? This is one aspect of the matter which we have taken note of.
Yes.
The other aspect is that it has not been accepted as well. The matter has been remanded. What do you say about this conditional remand?
No, my lord, there's nothing remains. Now, only aspect which,
that-
which is open is where how the community
That's
people.
right. That is what I have hinted. You know?
Yeah.
I'm not hinting. I'm only saying that this conditional remand means that it doesn't.
Virtually decided everything and thereafter it has been left open.
This is what I'm asking.
It's not done normally.
That's right. But why do we entertain this appeal? Why do we entertain this? Because your purpose is different.
No, my lord, my purpose is different in, no, my lord, no, my lord, kindly come to then Madhuri Patil's case.
No, but
No, Madhuri
where
Patil
is the
says, my lord, if,
just a minute.
because
Where
the
is-
mother is
where
liable for criminal
Where is
prosecution.
the locus for you
Exactly,
to see the process?
exactly, my lord. My locus flows from para 13, sub-para 14 of Madhuri
You're
Patil.
not the father.
Huh? No, mother.
You are not the father. You're a person who has been charged by one of these persons under the ST Prevention of Atrocities Act or maybe POCSO.
Yes, POCSO case.
So therefore, would you have the locus to challenge the
My lord, my locus comes from, my lord, sub-para 14 or para 13 of Madhuri Patil.
Okay.
Because yes, everything start, no, Lord will have to have a look at one more document, my lord. Page number 242. Otherwise, she never applied for, my lord, any certificate. Now, kindly see, when the criminal case was filed, thereafter this application was filed. Based on this, the certificate was issued. Please have 242, my lord.
Mm-hmm. 242.
Yes. For the first time on 4/8/2020, this prayer was made. With reference to the above, I'd like to inform you that I belong to Scheduled Tribe Miri community. Further, I was married to Nilutpal Lahon, a member of OBC, on 17/1/05, and two children were born out of the wedlock, Dibyanaya Lahon and so-and-so, now aged 14 and 9 respectively, so-and-so. However, my husband Nilotpal Lahan unfortunately expired on 4/10/12. At the time of my husband's death, my daughter and son were aged 6 and 2 years respectively.
Now, this is an application dated
4/8/2020. Now kindly come to the Millards,
just a minute. Husband died when? 2012.
12. Now please come to Milord, the second subpara. It may kindly be noted that judgment passed by the Honorable Supreme Court of India in Ramesh Bhai Naika, wherein it stipulates that children of single mothers can take on the caste of their mother if such child is brought up by single mother who belongs to scheduled caste, scheduled tribe, is treated as a member of the community, which the mother belongs and faces the same deprivation, handicaps as other members of the community to which the mother belongs. Further, similar honorable court judgment of Bombay High Court, etc., etc. Further, Section 4 of the Government of India dated so and so may also be referred to in this connection with the matter. In view of the above facts and circumstances, I therefore request you to kindly do the needful to issue a caste certificate in the name of my children, Dibyana A. Lahan, so and so, as belonging to ST tribe, submitted for kind perusal and necessary action.
And then
And
the
will-
matter, the matter was referred to the
No,
committee.
the certificate was issued. Then, my lord, there were litigations
No. So on this application, certificate was issued.
issued.
Thereafter,
We'll file objection, my lord. Then there was a litigation in this court. Eventually, matter was referred to state level scrutiny committee. And scrutiny committee came to the conclusion as is appearing at page 59 of the paper. Where, my lord, Ramesh Bhai Naika's propositions has been applied. And it was found to be not, eligible. And my lord, High Court in exercise of power under 226 is not supposed to make a roving inquiry, my lord. Please. Lord, if your lordship would kindly come to page number 351 for a moment. In one of the collateral proceeding, an order was passed by this honorable court. That is why that certificate was obtained. Please come to page 353, my lord. Page 353, my lord, towards the bottom of the page, last two sentences. It has been contended that as per irrefutable evidence, last two sentences, my lord. It has been contended that as per irrefutable evidence available on record, the victim belongs to general category. In this regard, reference has been made to the contents of the additional affidavit shown by so and so.
this Chief Justice's order.
Yes, paragraph 3, my lord.
Is in which proceeding?
We filed that petition, my lord, for quashing of the case, criminal case.
Oh,
Yes. Please come to para 3, my lord, at page 354. I hereby direct the investigating officer to conduct investigation as to whether victim belongs to SC/ST category and therefore whether penal provision of SC/ST Act can be attracted. For the said purpose, the birth certificate of the victim, the school certificate appended with the
this was beyond jurisdiction in a criminal proceeding. Even though the order was of the Chief Justice.
Okay.
Absolutely beyond jurisdiction.
But this is holding the
I will
field.
not take it,
Anyway.
Will not take it into
No, no, my lord. Why she had to apply? Why she had to invoke the principles laid down in Ramesh by the Naika, my lord? That is the reason. Oh, my lord, matter is otherwise very simple. If your lordship would kindly see, now the learned single judge applies the affinity theory, my lord.
We are not in a position to overcome that difficulty. That
My locus.
no, locus, yes, locus, and forget about your locus. Anybody can challenge if it's a wrong certification. It could be challenged by anybody because ST status or SC status gives so many advantages and
Exactly.
disadvantages vis-a-vis the society.
Yes.
Therefore, it could be challenged by anybody. No, it is not that.
Yes.
But for the purposes of having a defense in a criminal case, whether
Yes.
that could be the motivating
No, no,
factor.
that is partly and partly. Please have a look at sub-para 14 or para 13 of Madhuri Patel. 1994 6 SCC 241.
Right. What is the stage of the case, Mr. Chaudhary?
Milord,
What is the stage of the criminal case?
part charge sheet has been submitted. Charges has been framed. And Milord, there is also another challenge.
Now, it only depends on the
Now
quantum.
kindly see, Milord, the second writ petition is on discount. The second appeal filed by us.
You have filed 2 appeals.
No, yes.
Or the other appeal?
The other in one of the collateral proceeding, Milord, my locus was questioned and my challenge was negated. Therefore, I'm on writ appeal. My
No,
case,
your challenge was negated.
yes. Please come to page 256, Milord.
So therefore, we should have heard that first. Because that is the question which is plaguing us.
Can I not speak to Lordship?
We'll hear you.
Yes,
Without
very-
hearing you,
No, I
we
just
will
want to
not partake in
clarify.
it.
Milord will kindly come to page 256, Milord. Para 14.
256.
Yes, 256. It's part of para 13, 14. Because, my lord, in the absence of any statute, this Madhuri Patel judgment is considered to be a self-contained court. In case the certificate obtained or social status claimed is found to be false, the parent guardian candidate should be prosecuted for making false claim. If the prosecution ends in a conviction and sentence of the accused, it could be regarded as an offense involving moral turpitude and disqualification for elected posts or offices under the state or union or election to any local body, legislature or parliament. So this furnishes the cause of action to me. That's why I filed a petition where we demanded, my lord, the states should take action against them because state level scrutiny committee have found that the certificate was obtained fraudulent. Her claim is based on Ramesh Bhai. If you do not fulfill, you as a mother, you have done something wrong. Supreme Court has said, my lord, wherever the state governments have framed statute, that is a different issue. Otherwise, these cases are to be dealt with in accordance with Madhuri Patel's mandate.
Madhuri, let us be.
Yes. All the directions are in paragraph 13. Everything is given, my lord, how every directorate will have a, my lord, vigilance cell, that inspector of CID will conduct inquiry under the supervision of the SP. Then once there is a report, then there will be, the matter will be referred. And if the inquiry reveals nothing, then matters should end there.
Mr. Chaudhary, we are not getting satisfied with this Madhuri Latha, this paragraph. You know, there is a very subtle distinction. If you just leave aside the blinkers of the, blinkers which a
No.
which an appellant wears. Or
No,
which,
my lord, that's why.
just a minute. Just now, this is, please read. You have read paragraph 13.
Yes. 14, sub-para 14.
You have read paragraph 14,
Yes.
which gives you the locus.
Hmm.
And now come to paragraph 15.
As soon as finding is recorded by the scrutiny committee holding that certificate obtained was false.
Just a minute. Now, the claim here may not succeed because it is not in dispute that the mother is a civil caste, civil tribe. That's not in dispute.
No.
You're not disputing it. Whether the offspring from a forward father would make the offspring come in the category of civil tribe, this would be a claim which, if it doesn't succeed, the claim is unsuccessful. But does the claim necessarily become false?
No, it depends, my lord.
No. See, we are
No,
now we are taking the blinker from you and wearing it
no, my lord.
with us.
Then let us read
Now let us not see
14 and
that.
15 together.
Yes.
Let us read it together.
Yes.
As soon as finding is recorded by the scrutiny committee holding that certificate obtained was false, on
The
its
certificate
cancellation and
obtained-
confiscation simultaneously,
A
It should be
certificate
communicated
incorrect.
to the educator concerned.
Now,
or
Mr.
the
Chaudhary,
appoint-
please listen to me. I
Yeah.
mean, what is up till now, facts all right. We initially, we must tell you, I mean, unless I tell our views, unless we tell our views,
How do we persuade your lord?
how will you dispel that thought from the mind of the judges? Now, this conditional remand, we are not very agreeable, prima facie.
Huh.
If it has to be remanded, it has to be remanded with full vigor.
Yes.
I mean, the authority concerned must re-examine it. That's one aspect of the matter. But question is this: so far as locus is concerned, now an incorrect grant of certificate may not necessarily lead to an inference that the claim is false.
No.
Claim may not be sustainable.
Was the milord the beneficiary?
No,
But
no,
what
no.
about the parents?
One second.
And at that stage,
One
who
second,
play-
sir. This is he or she becomes a beneficiary only when that status gets her admitted in a college
Yes,
out of turn,
yes.
or maybe with weightage. Right. But here she is a victim. I mean, let us not take into account any background fact of any case and therefore the invocation of a particular section because of the person concerned, victim concerned being of a particular class. We are not taking it into account. But we're surprised whether suppose it were not there. Suppose you were not being prosecuted by this lady. And she would have been granted status or not granted status, would you have been concerned? Now that is the test. Forget about this Madhuri test and Vinayak Damodar test. Now, who are you to question this here? You can always claim, and then this order of the Chief Justice saying, directing for the correctness of the certificate issued. This is
investigation.
investigation. So investigation could be made that, well, notwithstanding the fact that the father is a forward, mother is a civil tribe, father died and mother raised the child independently. Those are different aspects. A police officer will not be able to decide this. So that investigation, even if it leads to any concrete result, would not affect
No,
the
Lord,
status.
will kindly see the attending facts and circumstances.
No.
Yes.
First you
Minus the attending facts and circumstances, what has fallen for your lordship is
whether
absolutely correct.
Whether suppose what you are saying is correct.
Yes.
All the three parameters met, the committee found that no ST status should be given. Does the claim become false?
Kindly see at what stage the claim was made. That's
right.
why I'm saying.
You have said that. You have said that. It is for the purposes of prosecuting.
Yeah.
But then the claim doesn't become false.
Not only, no. My lordship will kindly appreciate the circumstance in which this claim came to be made.
No, you're right.
Because
You're right there. Because
I'll just show one thing,
you
Lord.
just said, Mr. Chaudhary, that in school, the candidate had declared her to be a person of the general court.
Exactly.
So therefore, it is only for the purposes of putting the blame on you in a way in which you are punished on a higher.
Please come to page 474,
Agreed.
Milord, just to show the circumstance. 474 of the paper book. For a moment, Milord.
No,
And my lord, during the period when we have not brought that on record, my lord. I'm just sharing that information, my lord. During the period when the caste certificate was, cancelled by the state level.
I think
she took admission in Hindu College, Delhi, my lord, by using a forced certificate. We have not even brought on record those aspects.
That would be outside the scope of this. Outside the scope of this, you can prosecute the person concerned.
Kindly see, my lord, page 474.
One second, Mr. Chaudhary, we are not understanding this. Now, if it were so, then the matter was left pending. The ST status would not come to the lady, or SC status would not come to the lady unless it is finally decided. Now, once the matter has been remanded, let them take a call. Then question.
No, my lord. On the day when she took the admission in Delhi University, my lord, her caste certificate was cancelled by the scrutiny committee. That even that High Court judgment was not there. And she used that certificate to take admission in Hindu college. My lord, that aspect has an element of public interest because he's depriving somebody else.
We are not going to see this in this petition, in this appeal. We are that way focused.
My lord, may I
We
make,
look at it from a different
my
point
lord,
of view.
may I make one submission for a lot of time topic?
No, your first
I have,
silentio, you made a submission that it is this conditional remand means
is bad.
is bad. You give us some judgment on that,
Yes, we'll do that.
and we will consider it.
Yes.
Before doing that, these are only tentative observations. Let me
And
tell you.
I would also like to, my lord, support our, my lord, view on the locust part by referring to maybe one or two judgments.
right. So these are very, very tentative observations.
Very-
Don't neither of the
No, no,
neither
no,
of you
no,
advocates should get any idea
That much of experience.
that you have. The young man there, he also appears to have, because
Malad, I'm very, grateful. Malad, Lordship has encapsulated the whole case in
No,
such
no,
a
we
short
have
while. Prima facie, I completely agree, Malad, and we'll satisfy.
let's hear you now, and then we'll ask you to give, these are the issues where we would be focusing on,
Yes,
and then give us the judgments. We hear you another day.
yes. I'll be grateful, my lord.
Malad, I'm so grateful your Lordship has understood, and I see what is falling. What your Lordship.
Again, this is.
No, I have broadly.
Nothing is
saying-
falling from us.
Very well. Then I will start it on a completely clean slate, Malad.
Yes.
My lord is giving a date, my lord, of,
We will first hear it,
Yes,
and
yes.
then we decide.
yes,
We'll
Malad,
give a date for you to give us some law with
Yes,
respect
yes.
to
on
conditional
both the aspects.
Malad,
and locus.
Locus,
And locus.
certainly.
This locus doesn't satisfy us.
Anyway, well, in addition to that,
Madhuri Lata locus doesn't satisfy.
we'll supplement our effort, my lord.
Malad,
Yes,
on the-
With the
on the-
lordship's kind permission, my lord.
Yes.
Yes,
you want to
can-
go?
Yes,
Yes,
deep.
please.
Malad, on the lighter vein, when I was.
But we'll be, Mr. Chaudhary, in your absence, we'll be giving one introductory, part for.
Yes, of the order, yes. Of what is transpired today.
Actually, we'll not add anything from our side.
Yes,
Yes.
deeply.
As I said, Malad, on the lighter side, Malad, to start, when I was briefed in the matter, the young colleague here mentioned that reading the facts of this case, Malad, he remembers the idiom, Malad, on top of the chest, on top of theft, Malad, showing off the chest. Translated into Hindi, Malad, it is chori and sina jori, Malad. But be that as it may, Malad, because he molested me and now I'm being hounded by the very same person, Malad, who has molested me, Malad. Be that as it may. Malad, 3 propositions arise for your Lordship's consideration. Now, first proposition would be, Malad, I understand your Lordship's jurisdiction under 226 has certain limitations also, Malad. But why I said that idiom right at the beginning was that in certain facts and circumstances, under 226, the power is quite wide and extensive, Malad, and your Lordships has exercised the power in what is being said in para 77 in that context. The window opens up for me, Malad, of a interference with a finding of fact by the scrutiny committee if I'm able to demonstrate, or if the learned single judge has been able to show in his order, my lord, that it is perverse, 1. 2, my lords, the entire order of the scrutiny committee is based on assumptions and contention. The Supreme Court has laid down this small window as to when a single judge can interfere, my lord, and I'll make good this particular law. That's proposition 1. Proposition 2, my lords, I'll clearly demonstrate. Now, what does the single judge say, my lords? The scrutiny committee proceeds on the basis of a completely erroneous assumption and interpretation of Ramesh Bhai, my lord, and says that the moment the child has gone to a good school, the moment the mother is an IPS or a police officer, he gets excluded, my lord, from being a scheduled tribe. My lord, I ask myself a question, if that be the test, my lord, a person holding a high constitutional post, my lord, his child will never be able to get entitled to benefit, my lord, and that's not the law. And that is exactly what the single judge has said. The single judge has said the test which has been laid down by Ramesh Bhai cannot be individual centric, my lord. It has to be community centric. And that's the finding that the learned single judge has held based on the interpretation of Ramesh Bhai. Then, in my view, rightly so, coming all the way down from Indraswani and all of that, entire law has been placed down by the learned single judge. Then I'll make good each and every finding of the learned single judge and why he's come to those conclusions. The third proposition, my lords, is as far as the, and I'm so grateful, my lord, the lordship has, my lord, got the bull by the horn, my lord. What is his locus? What is his jurisdiction, my lord? Just my learned friend maybe may note down, my lord. The judgment of Ayub Khan, Justice Chauhan's judgment, my lord, clearly lays down who can challenge the grant of a certificate of a scheduled tribe, my lord. Unless he is a scheduled tribe or somebody, my lord. See, it is only those category of persons who can challenge the certificate. Single judge.
Or a person claiming admission in an institution.
Absolutely.
hosted by him.
Absolutely, my lord.
So by that logic, he would be prosecuted for a serious offense.
Yes.
If you were to be declared a procedural tribe.
Absolutely, my lord. I'm so grateful.
So therefore, it's something of the same genre.
Number one. Number two, my lords, the single judge tries to get into this, my lord. And I'll show those paragraphs. But he says, out of reverence and respect for the division bench, which is absolutely without jurisdiction, my lords, he says, I'll still go ahead and examine this issue. Otherwise, he was absolutely convinced that Ayub Bhai is the law of the land, my lords, and based on Ayub Bhai, he has no locus to proceed. And my lords, his interest, his rights may obviously be protected by this court. I have no problem, my lords. Any judgment or finding by the scrutiny committee or the fact.
Tell us some facts.
Yes, my
Now,
lord, very. May I?
You applied for.
My lord, if your lordships don't mind, for your lordship's convenience, I had
Give a
prepared.
copy to the other side.
Yes, of course, without fail. Well, there are two matters. I'm so sorry. Yes, I'm so sorry. I'm grateful, Malad. Malad, the facts in my respectful submission clearly show that I have been a victim of complete hounding, Malad, by this gentleman, Malad, who, therefore, Malad, that perspective that I put in right at the beginning, Malad. I will start, Malad, first with the maintainability or the locus or the appellant, Malad, hearing. Lordships will, before Ayub Khan, Malad, the Lordships will see the observations of the learned single judge on this aspect. It's absolutely clear. Lordships will straight away come to page 550 of Malad, the impugned order.
Then you refer to the
Volume 2, rate appeal 5. Yes.
refer to the paragraph of the judgment.
Well, it's para 17. I'll start with that. Well, there's 2 paragraphs, 3 paragraphs rather, 17 to 20.
Yes,
Lordship has para 17.
yes.
This court heard the learned counsels appearing on behalf of the parties and reserved its judgment on so and so. At the time of preparation of the judgment, a question arose as to whether, at the instance of respondent number 8, the legality of the caste certificate issued to the petitioner number 1 and her brother would have been entertained by authorities, which led to the present dispute. The question arose in view of the judgment of the Supreme Court in the case of Ayub Khan, reported so and so, wherein the Supreme Court held that to challenge the issuance of a caste certificate issued to the scheduled tribe, the person should either be a scheduled tribe or, in exceptional circumstances, when the actual person aggrieved of because of ignorance, illiteracy, inarticulation, or poverty, such person cannot approach, and then a person having no personal agenda can approach this court. Lordships will underline that. The moment my respectful submission, therefore, is, moment there is a personal agenda, he goes out. It is relevant to take note of that the respondent number 8 belongs to the general caste, and on account of being implicated under the relevant provisions of the Act of 1989, he challenged the issuance of the caste certificate in favor of the petitioner number 1. Under such circumstances, this court pointed out that the said aspect to the learned counsels representing the parties. Learned counsel appearing for the respondent number 8 submitted the respondent number, whatever my learned friend has said, he mentions that. Para 19. This court has given an anxious consideration to the submissions made by the learned senior counsel. This court also taken note of the earlier proceeding detailed in the previous segment of the instant judgment, wherein the learned division bench of this court had directed the SLSD should decide the validity of the caste certificate within a time frame. In the opinion of this court, as to whether an offense under the Act of 89 would have been charged with against the respondent number 8 is purely a matter of investigation, inquiry, and trial of the said offense, more so when attracting an offense under the Act of 89, and there is no requirement of a caste certificate. The writ court, in view of the judgment in Ayub Khan, ought not to have entertained the challenge at the behest of the respondent number 8. In fact, the judgment of the Supreme Court in case of Ayub Khan was never placed either before the learned coordinate bench or the division bench, be that as it may, taking into consideration that the learned coordinate bench and the learned division bench had directed the SLSC to decide the validity of the caste certificate. This court would not like to further engage in respect of the said issue, Malad. 3 propositions that I want to argue here, Malad. One, as a learned single judge points out, Malad, he comes from a general category. 2, admittedly, he says that I am wanting to challenge the certificate issued to this particular 2 minors because I will get affected in a proceeding, my lord, in the FIR that has been initiated against him by me. My lords, that clearly shows a personal agenda, my lord, which definitely cannot be while challenging a caste certificate. 3, my lords, how does issuance or non-issuance of a caste certificate affect him? That is an independent proceeding with regard to, my lords, that based on evidences and other attending circumstances. In these proceedings, your lordship can obviously clarify that those proceedings will go independent and separately. I have no problem, my lord. I have no problem if that observation comes from your lordship. With that observation, my lord, at least don't hound me. Let the scrutiny committee, my lord, do an impartial job. Just because you're in a high position as an IPS officer, you don't start dictating. Lordship sees the facts. Lordship has seen what happened. I make an application. The application gets accepted, my lord. I get the certificate. After that, he, my lord, challenges that by way of a notice, my lord. And based on that, in 2 days' time, the certificate is cancelled. When I rush to the High Court, my lord, immediately an order is passed, my lord, withdrawing that, my lord, rejection and sends the matter to the SLA. Obviously, my writ petition becomes infructuous. Then SLSC goes, and I will read portions of the impugned order, my lord, how the SLSC has proceeded, how the vigilance, my lord, the lordship will be shocked. Therefore, perversity, my lord. And therefore, the learned single judge was absolutely right in interfering and substituting his views, my lord, in place of the.
All right. We will hear you on the next day. You please prepare a compilation volume.
We have, my lord.
You have a compilation. Could you give it to us?
Happy. My lord, we have individual judgments. What I will do, my lord, before the last date, my lord, I'll put it tomorrow with the court master, today itself, my lord.
All
Judgments are not binded, my lord. I will share a copy with my learned
give
friend.
two copies.
Of course.
Because we'll be hearing you again, because Mr. Chaudhary will have to answer a few things, and
Yes.
you will also be required to answer.
Very
But let us put in prima facie what we have seen,
Yes.
without leaning on either side.
Yes, my lord.
And we'll just say some facts.
And my lord, if as an officer of the court, my lord, normally para 77 would, my lord, be an excess of jurisdiction under 226. And I completely bow down to that law, my lord, whatever is there. And I'm okay. My lord, let me say that upfront, my lord, without.
All right, Mr. Shah.
Yes, very
Then you make the job of judging easy.
But I have a but coming. My lord.
All right, but is always there. But is always there.
But the observations, my lord, put in by the learned judge, my lord, of course, has to stay. My lord, that would really prejudice me, because what the learned judge has done, my lord.
See, we would be we would be seeing this appeal
Yeah.
with a very limited perspective.
Yes, my lord.
We will not be getting into the facts of the
Yes, of course.
We will be looking at it from the point of view of the law with respect to the subject.
Absolutely. I'm so grateful.
We'll deal with it.
Yes, yes, of course.
Without putting anybody, any of the parties in any disadvantageous position.
Correct.
The fact is that the law comes to the aid and rescue of people.
Absolutely.
It doesn't harm, it
My lord,
doesn't hound any person.
If I'm entitled, I should get it.
Yeah.
That is all that I want, nothing more.
And it goes beyond the prosecution of the appellant.
Absolutely, my lord.
It has other
That is-
ramifications.
My lord, unfortunately, my lord, that has colored the entire committee. Had that not
No,
very
we
well, my lord.
will not go to this extent because that would be, I mean, there would be some discussion on a topic where we don't have any evidence. Whether it has been colored, whether the entire community has been, put to some disadvantage, or the machinery which grants such certificates, or the entire system.
My
Let
lord,
us
the
not get
1950 order itself, my lord, very well, my lord, I'll assist your lordship, of course. I'll hold my.
We have heard Sri K. Chaudhary, learned senior advocate for the appellant, and Mr. Pragyan Pradeep Sharma, learned senior advocate for the respondent. An FIR was registered by the mother of the victim by the FIR number 115 of 2020 for the offences under sections 354 of the IPC and section 10 of the POCSO Act 2012 against the appellant. The whole controversy with respect to issuance of the caste certificate to the child who was allegedly subjected to the misdemeanor began from here. The claim of the party are that the victim child was born out of a father who hailed from unreserved category and a mother who belonged to Miri tribe. The father of the victim died when she was 6 years of age, and she was brought up by her mother, who too was in public service. And associated with the appellant and his family. The death of the victim the death of the father of the victim had taken place on 4/10/2012. And the FIR referred to above was lodged with respect to an occurrence which took place on 31/12/2019. On the representation made by the mother of the victim, the FIR, in the FIR referred to above, various penal provisions under sections 3(1), then bracket Roman 11, then 3(1)(w)(1), 3(1)(w)(2) of the SC/ST Act 1989 was also added. This was contested by the appellant. But to no avail. While all this was happening, all Guwahati missing Kepang, MISSIN, missing Kepang, issued a certificate that the mother, we are not referring to the names
Yes, yes, of
for the reason of the act.
Of course. Well, just one interjection, if your lordship don't mind. The provisions of the ST scheduled caste scheduled tribes act, are not there in the charge sheet. Not
But
just
it was added in the investigation. We have said it added in
Yes,
the
yes,
investigation.
yeah.
We are aware of that.
Yeah.
What have you said? All Guwahati missing Kepang issued a certificate affirming that the mother had independently raised the victim with certificate was also endorsed by a senior member of the missing woman. First of later, on 21/8/2020, a caste certificate was issued in favor of the victim by the Deputy Commissioner, Kamrup Metro, on the recommendation of the All Assam Tribal Sangh. This was questioned by the appellant. When the district magistrate Kamrup, by his order dated 22/9/2020, cancelled the caste certificate earlier issued by the Deputy Commissioner Kam. This cancellation of caste certificate was challenged by the victim. But before any order could be passed in such challenge, the Deputy Commissioner who had cancelled the earlier caste certificate withdrew the order and referred the matter to the state level caste scrutiny committee for appropriate examination and determination. In the meantime, the appellant was seeking protection. The appellant, in an effort to seek protection from courts, got an order from the court, got an order in writ petition number 4523 of 2020, dated 21/10/2020, that in the criminal case lodged against him, the provisions of the SC/ST Act shall not be made applicable till the caste certificate in favor of the victim was finally decided. This was challenged by the mother of the victim. This order was challenged by the mother of the victim in Writ Appeal number 190 of 2020. Which was disposed of with the direction that the scrutiny committee shall verify the validity of the certificate in question within 15 days. But the investigation against the appellant shall proceed unaffected by the order dated 21/10/2020. In the meantime, on 31/3/2021, charge sheet was submitted against the appellant under sections 354/354A of the IPC, read with section 10 of the POCTO Act 2012. Now, curiously, no charge, curiously, the appellant was not charge sheeted under any one of the provisions of the SC/ST Prevention of Atrocity Act. Pursuant to such a direction, pursuant to such directions referred to above, the state level caste scrutiny committee issued a speaking order that the victim was not a member of the ST-P community, and as a result, also cancelled her caste certificate. This order was never communicated to the victim or her mother. Victim or her mother. On the basis of the aforementioned order of the state level scrutiny committee, the appellant emboldened by the observations made by the Supreme Court in Kumari Madhuri Patil and another versus Additional Commissioner, Tribal Development and others, 1994, 6 SCC 241. Namely, that in case the certificate obtained or social status claimed by a person is found to be false, the parent, the guardian, or the candidate ought to be prosecuted for making a false claim. And that if the prosecution ends in a conviction and sentence of the accused, it could be regarded as an offense involving moral turpitude, disqualification for elective posts or offices under the state or union, or elections to any local body, legislature or parliament, preferred a writ petition seeking initiation of both criminal and departmental proceeding against the mother of the victim for using a false caste certificate to prosecute him. This writ petition, bracket number WP number 1867 of 2020 was, however, dismissed. And the dismissal order referred to above was challenged in writ appeal number 388 of 2020. The victim also challenged the order passed by the State Caste Scrutiny Committee dated 24/9/2021 by writ petition number 8024 of 2020. The learned single judge set aside the order of the state level scrutiny committee, holding the caste certificate issued in favor of the victim to be bad. No. Issued the set aside the order passed by the state level scrutiny committee, whereby the caste certificate issued in favor of the victim was held to be bad. However, the learned single judge observed very categorically that the victim was under the care and custody of her mother after the death of her father. And since the mother hailed from a tribal family, she did not get any advantageous start in her life, despite her father being a non-tribe, and that the victim, along with her brother, were raised under such circumstances when they suffered deprivation, indignity, humiliation, and handicap. This, according to the learned single judge, was acknowledged by the members of the tribal community. However, whether it was perceived by the people outside the community was not very clear from the records of the case. So precisely for this reason, the learned single judge thought it appropriate to remand the matter to the SLSC to decide only that aspect of the matter, namely whether people outside the community of the victim family also identified her and her family to be belonging to the tribal community. The tribal. The Land Council for the appellant, while questioning the aforementioned judgment of the learned single judge, has raised several issues, including that such conditional remand to the statutory authority only amounts to dictating the terms for passing a fresh order in a particular manner, in a particular way. Thus, according to him, the scrutiny committee will be left with no option but to pass an order against the appellant and in favor of the victim. The other ground of challenge is especially to the holding of the opinion of the scrutiny committee to be bad in law, that the committee had seen the entire aspect of the matter and had decided that the victim never came from the victim could not have been granted a tribal status. This ought not to have been lightly disturbed by the learned civil judge, who did not have the necessary wherewithal to decide such factual issues, and therefore had a limited jurisdiction to test whether the order passed by the scrutiny committee was within the parameters of law. The last of the submission on behalf of the appellant is with respect to the justification of his locus to challenge the issuance or non-issuance of a caste certificate to a victim who has alleged misdemeanor against her, against the appellant. It has been submitted that since he would be directly affected by the decision either way, and that he would have, and he would, and that his directly affected, he has a locus, notwithstanding the observations of the Supreme Court in Ayub in Ayub Swans, wherein an objection by a non-civil caste or civil tribe person, or what have I said? He has a locus to challenge the decision regarding grant or refusal of the caste status, grant or refusal of caste status to any to the person concerned. Mr. Sharma, learned advocate for the Mr. Pragyan Pradeep Sharma, learned advocate for the respondent, however, has found that however has disputed that the appellant would have any locus in the matter, and that investigation in a criminal case, investigation or prosecution in a criminal case, even though, which in this case would be linked to, in some way or the other, the status of the victim, would not be wholly dependent on any discussion on the validity of the caste certificate or validity of the caste certificate or its cancellation by the authority. Apart from this, it has been argued that the victim is continuously being hounded by the appellant the apprehensions of the appellant are absolutely uncalled for him to gain any locus, as even the charge sheet has not been submitted under any one of the provisions of the SC Prevention of the Law. After having heard the learned counsel for the party, we deem it appropriate to direct the learned counsel for the party to provide a convenience volume along with the case law, especially with respect to the locus of the appellant, to challenge the order passed by challenge the grant of ST certificate to the victim when he himself does not fall in the category of any does not fall in any reserved category. Let this matter come up for consideration on. We have just said the
No,
facts.
that's all.
Just the facts. How criminal case was
And
lost.
tentative view only.
No,
That is a tentative. No view we have.
no view.
We have only put words in your mouth.
Right.
No views. No, see,
No, it's okay, Milord.
the
It's
way
all right.
you're adverse, if you're adversely affected, you have a locus.
Yes.
Now, we will not go by Madhuri Lata, we will go by Shah Babu Tinji.
Yeah.
Ayub Khan is different. That is in the context of challenge to the certificate per se.
The Ayub Khan, Noor Khan,
Ayub Khan Noor.
that person aggrieved.
Ah.
That is a different.
No, therefore, we'll go by Shah Babu Tinji.
Yes, yes,
Whenever,
Kinji.
whichever proceeding somebody is aggrieved, he has a forum. He can't be
Yes.
rendered remediless.
Kinsey is slightly broader, Milord.
It is much broader, and I still believe in it.
But that's a go-to judgment as far as all Delhi High Court lawyers are concerned. Lordship knows for everywhere, for that matter. Actually, it's a benchmark.
Yes, yes. So we give a date sometimes in November.
Oh, that will be too. The difficulty is, Malad, there is a stay as far as Malad, the committee going ahead and deciding the issue is concerned.
We remove that stay.
No,
Yes.
there is stay.
And-
Otherwise, the committee will go ahead, Milord. And
No,
then
that
now,
is the
at this
difficulty.
stage,
Then we hear it.
give an early date, Milord.
Yes, Malad, please. And I'll be very grateful, Malad, because what
No,
had
no, even
happened.
we won that.
Malad, I took admission in Hindu college, but because I realized this, I withdrew. I've come back to Guwahati, Malad. I withdrew that admission.
Immediately after the opening, October
Yes, yes.
Very well.
14th October.
14th.
14th
14th of October.
14th of October.
Check up your calendar.
Okay. Let it be 16, Milord.
16th.
16th
It's a
is better
Thursday.
for me.
All right.
Grateful, Malad. So great.
Before your lordship's rise, can I make one small prayer, Milord?
Yes.
Till I'm going to Itanagar now, Milord. There are two matters, Milord. My junior will make a mention at 2 o'clock.
Which are those matters?
Milord, item number 5 and 8, Milord.
Oh, we have not still reached 5. Oh,
5 to 8, Milord.
5 to 8.
Yeah. Oh, 8 is already gone. Yes.
5 and 6.
5 and 6.
5 and 6 are again the same judgment. I'm appealing for the state.
Actually, there's an appeal by the
There's an
state
appeal by
and
the
appeal
state.
by us.
Penalty imposed in a disciplinary proceeding.
5 and 6, all right. So we hear on top of it.
Yes, Milord.
Convenient for you?
Yes, sir. 16. 16th is the Tuesday.
11 years now. And you want adjournment in item number 11 as well?
11 also, Milord.
Again.
11 can be deferred, Milord. There is no difficulty.
And 5 and 6?
5 and 6, my learned friend says yes. There's no urgency as
Yes.
such, Milord.
Or it could
We
be
hear it after
Yes.
After-
After the vacation.
After
Milord.
as prayed for on behalf of the appellant and agreed to by the counsel for the respondent. Let the matter be, let this case be listed on 23rd of September. Okay. At the instance of the Let it count for the appellant. The matter is adjourned to give a date in October 11, item number 11. Somebody is appearing online. Are these?
May I please your lordship?
2810, 11th.
Uh,
11,
sorry.
2810.
ठीक है come on.
All right.
All right.
Yeah, but yeah.
We come back at two. Yeah.
Supplementary list for orders, item 49.
This is connected to the item number 13 to 35, my lord. So here, my lord, we have already served a notice upon the respondent, sole respondent to Dusty. So my lord, we condone the delay, my lord.
I will be condoning the delay. Despite service of notice on respondent number 1 by registered post as also Dusty, nobody has appeared to contest the application seeking condonation or delay of how many days?
213 days.
230 days in preparing.
One.
In preparing. One in the appeal, preparing the appeal for the reasons stated in the application, as also the fact that the issue is sub judice. The issue in this appeal is sub judice. In many of the appeals, we condone the delay and direct the registry to place this appeal, place the appeal along with
Rate appeal 287, 23.
along with the appeal along with 287 of 2023 and other analogous appeals on give or take. So, that matter will take it up now, just now.
Okay.
Who appears in all these appeals? 13 with
13 to 43.
13 to 43. Yes.
It's senior government advocate.
Can you inform him?
Yes, my lord, I will inform.
Date be keep it open ended. We'll see. Along with that on Sunday.
Oblige, lord.
For hearing, daily list, item 9.
May I please your lordship? My lord, may kindly take up this matter after some time, lordship. My senior is on election
Who
code.
is your senior?
HK Das, lordship. He is on election code number 3,
That's
lordship.
good, but what do we do now?
In a special bench, lordship. May kindly take up this matter after some time, lordship.
Tomorrow. We'll
Yeah.
hear you tomorrow.
Tomorrow.
Yeah.
Tomorrow. Day after.
Lord.
Day after. Yeah. On account of difficulty of the council who is to address this court, let this case come up for consideration on your date.
Item 12.
Yes. He is known. He is known. Dies not. He is. Yes.
May please your lordship.
Now you're looking at him. Why?
No, no, I'm just taking my file.
So you are asking for your file.
Yes, yes. Lordship, Mr. Kane should leads us in this matter, your lordship. Due to some
But no,
reason,
no, there was the.
due to
This is
some
not
reason-
item number 11. This is 12.
Lordship, he's appearing for the respondents in item number 12. State of Assam versus Debashish Pujari. Board of
What do we do? But you have not counted, you have avoided counting the seniority.
But we have avoided counting the
You
seniority.
can't do that.
But the seniority he will not get.
Why?
Otherwise, my lord, from 2004 July, my lord,
What is the principle?
my lord,
D is none.
there is not.
D is none. So
Lordship.
Haryana versus state of Haryana versus OP Gupta. I think that's very, very clear.
But
1996, have you examined that? 1996, volume 7, SCC 533.
I'll keep. Fine.
See, rules of recruitment I mean, it does not interrupt the continuity in service. Promotion and seniority are in accordance with the rules of recruitment.
Well,
He is known is only marking him absent.
but
That nothing, he was not there.
in fact,
So for all other purposes, for computation and other things, seniority you can't possibly think of. The law is very well settled. It's he is known is only a neutral comment, Mister. And it is not an adverse marking.
well, my humble submission is below that Diasnon, if Diasnon will not entitle him for any benefit, any service.
Benefits all right, but seniority would not be in the
Lordship,
category of the benefits which you can avoid.
Lordship, may I kindly consider one thing, Lord.
Anyway, we'll be hearing it only in the presence of the
Ma'am,
counsel for the other
Ma'am.
side, but you please examine this
I'll
case
accept.
which I have told you.
I'll accept.
The law is absolutely clear. You can avoid paying him all the dues, other things for that period. His pension also will be calculated minus that period. But so far as seniority is concerned, that is governed by the recruitment rules. I mean, there can be no dispute about it.
I'll show the rule also, Lord. And one thing, Lord, ultimately there has to be a qualifying service. So the person was unauthorizedly absent during that period. He has no experience
Yes, so
in that
that
cadre.
could be an indirect way of taking away the seniority thing from him, but not for the purposes of does not.
Lord,
Suppose a person is declared yes known for say 6 months, and if within that period he would not be given any enhancement of pay, and which would be prejudicial and which would be a factor which would be taken into account for giving him promotion, then of course yes, but otherwise you can't change the seniority.
Lord,
A very clear
in this case, Lord, in this case,
forget about the case. Facts of the case we'll see.
No.
But on principle, you can't tinker with seniority in this case. Unless it has the effect of only affecting the seniority indirectly. If you can make out a case that not as principle, but in this case, the enhanced pay or the what is that increment was not to be given to him. And if that were the reason for not giving him higher promotion because of the qualifying service slab, then of course, then you're justified, but not otherwise.
there are two appeals.
Please,
No, no,
please
of course,
be,
of course,
please be
Lord,
sure of the law, and then we'll hear you on the next day. When you want it,
Lordship, any date, please.
then we give you in October.
Lordship, if it can be accommodated in this month.
This month is not possible. On account of the preoccupation, on account of the absence of a prayer for adjournment has made on behalf of the respondent. Respondent. Let this matter come up for consideration on debate.
30th October.
Check the law.
I'll check up.
It can only affect indirectly, not direct.
Here, look, I'll paste.
Item 13 to 43.
Outline. No.
No, we have not. We have not yet. Yes, you left your file. I mean, you must carry your file yourself.
No, I'm led by my learned senior Mr. Additional Advocate General Santha. He's on his way.
Mr. Advocate General is on his way. When will we pass it over for some time?
Give me 2 minutes. Look.
Item 44.
Lordship, may the matter to pass over for the time being.
May I
Lordship.
please your lordship?
Yes,
May I please your lordship?
yes.
Your lordship, as per the
Let's
last
see,
of
let's
the,
see whether he makes out a case for interpreter, then we'll call it for. Yes,
my lord, your lordship, this matter primarily challenges the various of 43D5. The issue is that your lordship will appreciate that 43D5 is a special provision with respect
we
to
are
grant.
aware of Mr. Porgoin. Mr. Porgoin, we are aware of 43D5.
Yes,
And we are also aware of the judgment of Supreme Court in NIA versus Zahur Ahmad Patali.
yes, my lord. I will come to that.
Now, how will you question the virus of it when it has already been approved by the Supreme Court?
No, in that Amritsar Watali's matter, your lordship, which my lord was referring, that was a case where the Honorable Delhi High Court has reappreciated the entire evidences at the time of grant of bail.
It is
That
not only that. It is not only that. The question of validity also was discussed. And thereafter, K. Najib, where also there was a delay of about 9 months, agreed it was for the purposes of grant of bail. But then in the last of the cases of Vernon Gonsalves,
My lord.
if you're aware, the division bench also agreed and said that the provision is valid, it's constitutionally sustainable, but there was only discussion with respect to a standard of prima facie true. I mean, how to decide whether a case is prima facie true. So I don't think the issue is left open now.
My lord, I will respectfully disagree if your lordship permits me for 2 minutes.
You may disagree, but then we have read the judgment. You
My
tell
lord,
us from the judgment whether the validity has been questioned, it has been decided or not.
No, my lord, if your lordship will kindly come to Amritsar Watali's matter.
Let's have Watali.
Watali, my lord.
It's 2019, 5 SSC.
2019, 5 SSC 1.
Yes.
Kindly come to para 21. Para 21, where the Honorable Apex Court.
Just give us a minute.
My lord.
Para 21.
My lord, para 21.
Yes.
Here this Honorable Apex Court goes away, tries to draw out the Amrani Tripaঠি's case and set a settled principles of while granting bail. What are the criteria? Now, 43D was being discussed in para 22. It commences. My lord will kindly come to para 23. Para 23.
Yes.
By virtue of the proviso to subsection 5, it is the duty of the court to be satisfied that there are reasonable grounds for believing that the accusation against the accused is prima facie true or otherwise. Our attention was invited to the decision of this court, which had an occasion to deal with similar provisions in Tada and Mokoka. The principle underlying those decisions may have some bearing while considering the prayer for bail in relation to the offences under the 1967 Act as well. Notably, under the special enactments such as Tada, Mokoka, and the NDPS Act, the court is required to record its opinion that there are reasonable grounds for believing that the accused is not guilty of the alleged offence. There is a degree of difference between the satisfaction to be recorded by the court that there are reasonable grounds for believing that the accused is not guilty of such offence and the satisfaction to be recorded for the purpose of the 1967 Act that there are reasonable grounds for believing that the accusation against such person is prima facie true. By its very nature, the expression prima facie true would mean that the materials evidence collected by the investigating agency in reference to the accusations against the accused concerned in the FIR must prevail until contradicted and overcome or disproved or by other evidence. And on the face of it shows the complicity of such accused in the commission of the stated offense. It must be a good and sufficient on its face to establish a given fact or the chain of facts constituting the stated offense unless reverted or contradicted. In one sense, the degree of satisfaction is lighter when the court has to opine that the accusation is prima facie true as compared to the opinion of the accused not guilty of such offense as required under the other special enactments. In any case, the degree of satisfaction to be recorded by the court for opining that there are reasonable grounds for believing that the accusation against the accused is prima facie true is lighter than the degree of satisfaction to be recorded for considering a discharge application or framing of charges in relation to offense under the 1967 Act. Nevertheless, we may take guidance from the exposition in Ranjit Singh's Sharma, wherein a three-bench judge of this court was called upon to...
Decision of the Delhi High Court was reversed, and
Yes.
There is no specific averment with respect to
virus of validity of 43D5.
same grounds would be pressed.
No, it was not been pressed, my lord. Your lordship will kindly see, I will give an example. Yes, prima facie true, that's fine. Because in Jayanta Kumar's case, in Jayanta Kumar's second case, our High Court has interpreted this provision. When the first time these matters were put to challenge in the various bail matters. Now let me give an example. In UAP, what is been saying is that the materials that has to be considered is the FIR or the final report, that is 173 charge sheet. Now, my lord may take an example is that if a charge has been framed against me, I go for trial and the witnesses get diluted, evidence get diluted. Now I file a bail application before the special court. The rider is that the learned trial court, special court cannot look into those evidences. It will be restrained to the FIR or case diary. That is the issue which because in other NDPS acts or other special enactments, there has to be a come of opinion that he has not committed this offense.
Let us see Gonsalves now. This we have seen. Let us see NIA versus Vernon Gonsalves.
Please get NIA versus Vernon Gonsalves.
This is 2023 matter.
My lord, my lord. My lord, may kindly give the citations. I am not having the judgment.
Read that judgment and then argue. 2023, 9 SCC 442. We are not supposed to give you judgment. You are supposed to tell
No,
us.
what I can assure your lordship is that the virus of these provisions has never been challenged. It was challenged.
Go through the judgment. Tell us on the next date. The lawyer for the other side is not here. On the next day. Okay, let this matter come up for consideration. I mean, it's no use, arguing a matter which has been decided. Of course, not with respect to the virus, but it has been approved, affirmed, decisions have been taken, and the logic given also we understand. It is the same thing. Anyway, we'll hear you and pass a judgment.
My lord.
On the next date.
My lord.
Go through Vernon Gonsalves.
My lord.
We'll and counsel for the petitioner's brother. There is a prayer for adjournment. On behalf of the state. On behalf of Union of India. On behalf of Union of India. Let this matter come up. Today is Tuesday, 14th of October.
Oblige your lordship.
Gonzalez judgment with a place for
Item 13 to 43.
I have to change my prayer. Lordship may kindly accommodate me for, kindly take it up on Thursday, day after tomorrow.
All right, have you informed the other side?
Yes,
My lord, there is some.
My lord, I am representing only 3 cases, my lord, but Tuesday it will be not convenient for us because already 3 case has been fixed, my lord. I need some of that.
There is some urgency in the matter as we presume because many applications for compassionate appointment will be pending. Mr. Nath, you'll have to justify many things. This criterion of 3 years in service,
Yes.
this does not appear to be rational. Don't grant compassionate appointment if death has taken place long time back. That's one aspect of the matter, but not on this ground. See, there cannot be any prediction about death. A person dies in harness, even if he has died, say, when less than 3 years of service is left. Can that be a ground to avoid giving compassionate appointment?
There has to,
Same effect on the family. It's the purpose is to provide succor to the family, to take them away from destitution. So this, I mean, suppose that death has taken place sometimes in 2012. It is being decided in the year 2025 for whatever reason. That may not succeed because even if it is because of your inaction, it stands diluted, because the concept is that the benefit has to be given to the family members of the employees.
immediacy to give them relief.
Immediate succor to the family. But does it have any nexus with the number of years of service left for the deceased employee? Suppose a person dies at the age of 57, retirement age being 60, and then he has a child. I mean, the family, there is nobody to look after the family. Now, on what ground do you deny that? The same thing could be for 5 years, could be for 10 years service left.
Compassionate appointment is,
That principle wise, Mr. Nath, don't tell us. We know compassionate appointment is a special appointment. It's a backdoor appointment. We understand all this. We are only asking you, do away with the compassionate appointment. That is a policy of the state. We will test it. But then putting this rider that it shall be considered only for the family member of a person who dies with more than 3 years of service left in his kitty. This does not sound rational.
The family pension, this is
Anyway,
about the
you-
family
you
pension.
Look at it, prima facie, we are not agreeable to this proposition of the state. Let's see what the Advocate General has.
Lordship.
Take that.
Not on 9th, my lord, or can it be on 11th, my?
11th of September.
Yes, my lord, this one.
11.
11th of September, this bench would not be available.
9th, my lord, I got some other work, my lord.
Tell us a date after October holiday. We keep it on 14th of October.
Will do, my.
All right?
Well,
14th.
14th of October.
14th of October.
After long vacation.
Let all these appeals be listed. On 14th, as I did, a prayer for adjournment has been made in all these cases on behalf of the learned advocate who is engaged in another case, Additional Advocate General or Advocate?
AG, madam. AG.
H.
Lordship.
Advocate with case another. Let these are appeals. Let these appeals be lifted. On 14th of October.
Obliged.
Obliged. 49.
Along with that, item number 49. Place it to yeah.
Item 47 and 48.
We are appearing in item number 47. Lordship.
Yeah.
Here, Lordship, we have challenged the revision of pay rules 2016, wherein a discrimination has been made to the staff nurses who have obtained BSc nursing degree. Whereas your Lordship, 1991 rules which holds the field has not been changed, my lord. But while enacting your Lordship, this revision of pay rules, they have made a cap by giving benefit to the persons who have obtained the graduate degree, but discarding the persons who have obtained diploma. We are diploma holders, your Lordship. Lordship, may kindly have a look at the notification dated 95 to 91, your Lordship. Please, yeah. In fact, Lordship, government is
Which law have you brought?
1991 rule, my lord. Law.
No, no.
Oh, Lordship, we have.
With respect to qualification?
Yes. Qualification parity, I'll be relying on Article 14, my lord.
Article 14 is a general argument.
Yes, my lord. Regarding qualification, your lordship,
Who appears for the other side?
I'm appealing.
Health Department has they have filed an affidavit. They relied, two affidavits they filed and they have supported our case. But Finance Department, they say, their lordship, they'll be formulating
Unfortunately for you,
my lord.
there is a judgment of division bench of there is a judgment of judgment which says that this classification is correct. And the difference is only of grade pay.
Yes. Lordship, in fact, Lordship, on that same point, Lordship, I have three Supreme Court judgments. While classification,
Give that.
But lordship, we perform the same duties and responsibilities.
Followed that
My lord.
case. You
My
rest
lord.
your case on that point
My
only.
lord. And Health Department has filed an affidavit. They say lordship, they'll be formulating draft rules.
Health department would not be the controlling department. Money has to come.
Money. My lord, I understand. Finance. They have not filed an affidavit yet.
Lordship, on this one, I'm relying upon four judgments, Lordship. First one is 2004, 4 SCC.
No, the later one. Give us the later one.
Latest one I'm having, Lordship, it's 2021.
Give us the photocopy. Will not be stretching our arms.
Lordship, I have furnished the booklet.
You've given the booklet.
2021, 15 SCC, 650. Paragraph 31.
Which
Yeah.
paragraph?
Paragraph 31.
Paragraph?
31. 31. Mary.
Yes.
Way back in 1968, the Constitution bench of this court held in the state of Mysore versus P. Narasingha Rao that Article 16(1) does not bar a reasonable classification of employees or reasonable test for their selection. It was further held that the provisions of Article 14 and 16 do not exclude the laying down of selective tests, nor do they preclude the government from laying down qualifications for the post in question, despite the fact that the competing parties who were before this court in the said case were employed at Treasury, carrying out the same duties and responsibilities. The bench held in that case that the classification of treasurers into two types with different grade of pay on the basis that one type consisted of matriculates and the other non-matriculates is not violative of Article 14 and 16. That is my point now. That is one judgment, Lordship.
This was for promotion, no? But for pay
No.
also it says a word.
Lordship, for different grades of pay.
The other judgment that
Lordship, another one, Lordship, I'm having, this is 2004 4 SCC 646.
who appears in item number 47, 48.
Europe. Paragraphs 12 to 20. 1 to Europe.
Yes, the other one.
But the third one is 1974 1 SCC 19. Paragraph 34 and 35. Paragraph 34 and 35.
Page.
page 34, Lord.
Which judgment?
This is 1974, one.
State of JK versus Trilokinath.
No, so this is state of Jammu Kashmir versus, yes, Trilokinath.
Trilokinath.
Page 34, paragraph 34. Paragraph 34 on the first 3-4 lines, Lordship. On the facts of the case, classification on the basis of educational qualifications made with a view to achieving administrative efficiency cannot be said to rest on any fortuitous circumstances, and one has always to bear in mind the facts and circumstances of the case in order to judge the validity of the classification. Then I am coming to paragraph 35. One judgment on this point, Patrick. So for these 3 judgments are concerned, this is on the point of reasonable classification. And the 4th one, Lordship, I'm relying upon, this is 2007 8 SCC 279.
That's on which point?
This is on the point of equal pay for equal work. This judgment, in fact, Lordship, later on followed in many judgments by the Supreme Court, Lordship. This is a SC Sandra judgment. Lordship. Paragraph 35, 36, and 37.
Paragraph?
Paragraph 35, 36, and 37. Okay, if Lordship permits me to read now. In our opinion, fixing pay scale by court by applying the principle of equal pay for equal work upsets the high constitutional principle of separation of powers between the three organs of the state. Realizing this court has in a recent year avoided applying the principle of equal pay for equal work.
That's a mere. They are not granting that. They are only questioning the exclusionary provision.
Now, if Lordship comes,
They have questioned only the exclusionary provision, and that also by way of, comment
no,
in the ROP rules of 2017.
I'm also not only one word.
With
Lordship,
no equivalent change in the nursing routes.
yeah, no,
That's
only
the only
one
error.
word. This is wholesale identity. That one word, Lordship, I hope.
That's with respect to the powers of the court to decide.
Yes.
That equal pay, therefore equal work, therefore equal pay. That we are not, that we are aware of our limitations. That we will not do.
Lordship comes to the rule, Lordship, recruitment rules, Lordship.
Yes.
That is at page 15.
Page 15 of the brief.
Of the writ petition, Lordship.
Page 15.
Page 15 of the writ petition.
Of the writ. Show it from the appeal record. It's not here.
Lordship,
This is not
separate
appeal.
UAPA,
This is
rule of 1991.
Lordship in the page 15. This is the amended one. Yes, Lordship.
1991.
This is the type portion, Lordship. 15 is the type copy, Lordship. If Lordship comes to page 15A, serial number 8. This is the academic. The academic and other qualification of a candidate for direct recruitment and promotional posts shall be as prescribed by the governor or the appointing authority as the case may be from time to time. The qualification and experience prescribed as on the date of commencement of this rule are given in Schedule 3. Lordship, in the first rule, that Schedule 3 has not been enacted. But in the year 1998, Lordship, this rule was amended.
But no change has been made.
That amendment is at page 27. And if Lordship comes to the schedule, Lordship. Schedule is at page 33. Serial number 4, staff nurse.
Yes.
This is the qualification for staff nurse, Lordship. BSc degree in nursing. No, Lordship, this is 98, page 27. 15th of September, 1998. Page 27. I'm sorry, Lordship. I'm in writ petition 297 for 2020.
Which section of the rule are you?
Lordship, I'm in the next case, Lordship. 48, I think. I'm in 48. The second case. I'm sorry.
Yes, page.
Page 27 is the amended rule, Lordship, 1998. And the schedule starts from 32, page 32. Relevant portion is at page 33. Serial number 4, staff nurse. BSc degree in nursing or candidate who have passed PU examination and have undergone 3 years diploma in nursing and midwifery prescribed by the Indian Nursing Council. Now, the consideration was that, Lordship, for BSc holders, there was no separate post was earmarked, Lordship. And that is why, Lordship, in the Pay Commission recommendation of 2017, a grade pay of the staff nurses having BSc degree, Lordship, was enhanced to 8,700. And those who have all diploma degree, Lordship, they will remain in the earlier position, Lord. That was the only distinction.
They take only right the type of deputy cap. Qualification. But get equity or different. Directed what now for a staff nurse, what is the qualification for that recruitment?
BSc or diploma.
Diploma. We are diploma holders, Mike.
Where do we this new schedule?
That is schedule 3, Lordship.
Your Lordship.
It says for a staff nurse with BSc nursing or candidate who has passed EU exam.
And have undergone 3 years
EU is
diploma.
higher secondary.
Huh?
It's class 12.
EU is higher secondary and has 3.5 years E&M training course.
So after higher secondary, 3 years diploma course. Lord.
This is the diploma.
Yes, we belong to that class.
There is only one distinction so far as promotional avenue is concerned. They can't go to the rank of joint director.
And that is why, Lordship, a separate recommendation was made to formulate a separate rule so far as the promotion aspect of this BSc nursing are concerned. And that is where the health department moved the finance department with a draft rule, Lordship. That is not yet finalized. That is for subsequent law.
Lordship, may I like to refer? Mild.
We have followed your argument.
Lordship, initially this was recommended by the Pay Commission. Subsequently, the matter was placed before the Anomaly Committee. And if Lordship comes to page 44 of the petition, anomaly committee says, committee finds no tangible ground for interference with the existing recommendation. That is the anomaly.
Thereafter, the state adopted it.
State recommended not. Now, stand of the finance department is that it is a pay commission's recommendation, so we are bound by the recommendations of the pay commission, so we are granting that. But if lordship comes to the prayer of the writ petition, lordship, and if I have understood correctly, lordship, they are not saying that give us at par with the BSc nursing PhD degree holder.
What else they are saying?
They are saying don't give them the recommendation of the pay commission. Lordship, may kindly read this page 10A.
That's unhappy drafting. They can't
Yes.
do that.
Lordship, yes, not in a petition.
They are saying, setting aside the provision incorporated in the Assam Service Revision of Pay Rules 2017, whereby provided preferential provision for staff nurse having BSc degree.
Meaning thereby that you put them in that category, or have a standalone, pay band for everything.
But whatever it is, Lord, that is a prayer. Even if it is accepted, that they are saying that also give us also at the level of 8,700.
Lordship,
Unfortunately, you have no case now.
Lordship, I'll try to make out a case, my lord, and I'll be relying on the affidavit filed by the health department. Lordship, a view was given by the finance department. They cannot go beyond that, your lordship. May kindly have a look. The affidavit filed by respondent number 1 in WPC 2974.
Affidavit is
Lordship, Lordship, may kindly have a look, my dear, with me, my lord. Lordship, what they have said, as regards at page 75, as regards GP of staff nurse, Health and Family Welfare Department may take policy decision and resubmit after due decision.
You would do a better job if you tell us. There are some decisions of Supreme Court which says that all this apart.
Yes, I will. Lordship, please to give me time.
You say yes.
No,
Can
Lordship.
you tell me what the court was going to tell you?
No, what I was referring. I'm sorry, your lordship.
If you don't allow the court to complete the sentence,
I'm sorry, your lordship.
help you out for the reason of parity and many other things. You jump over and you say yes.
No, lordship, I
Allow
will.
the
I will
court
find
to
out.
say, I mean, the court is always in favor of the
Lordship, I understand.
Why do you have to do such great hurry? No, find out there are 2-3 judgments of Supreme Court which say that notwithstanding the right kind of classification based on educational qualification, but if it is one unit where there is no difference at all so far as the work is concerned, so far as the initial recruitment is concerned, then there should not be any change in the grade way. If you find out that decision and tell us it is only with respect to midwifery and nursing, you can have some judgment.
Lordship, we'll find out.
Please find out and tell us. Just don't say yes. The classification, he has argued only on law. He says that classification based on educational qualification is a valid classification.
My lord.
That is what he says.
Lordship.
But that does not necessarily mean that persons, even at the entry point, there is no distinction. The work profile, no distinction. Promotional avenue, all right. But why? Promotional avenue, all right. You will have no objection if only BSc nursing would get promoted to the post of deputy secretary, of the post of joint secretary. That restriction you have in your service because of lack of, higher qualification. But then so far as grade pay is concerned, why should it not be given to you if it is being given to all staff nurses across the board? That is the question. Now, staff, the pay commission evaluates the work profile and then decides. But then it is not necessary for the state to accept it or not to accept. So the state has accepted it because the anomaly committee found the distinction to be valid. Now you can come up with some case law which says that when the source of entry does not make a distinction, when the work profile does not make a distinction, whether this classification would be all right. Classification on principle is correct. On educational qualification, there can be a classification. Make that effort if you want us to.
So far as same nature of work, Lordship, I have already placed one judgment.
They are same nature of work with the same level of entry. No stoppage. You're not stopping diploma holders from becoming staff nurse. And that's a qualification for BSc nursing also.
But on this point, I also face 2-3 judgment. I have
Please
lot-
find out and tell us. Just don't insist on what you have written in your prayer. If you insist only for that, he has a good answer.
Understand.
Academic
I was-
qualification, classification is okay.
My
Go
lord,
ahead.
I was relying on the affidavit which supports us and views of finance department
When
is
law is being
incorporated.
argued, argue law.
My lord. Lordship.
Affidavit, suppose the health department files an affidavit, so what do we do?
No, their suggestion is also given in positive, affirmative, suggestion of the finance department. That's what I wanted to make the submission.
Then go before the finance department. Why do you have to come here? Let the finance department take a call.
As of that, they have not filed their affidavit. No, there is
Who
making a.
appears for finance department?
In second case,
You are appearing for finance department. What is the view? She says we have not examined.
No.
She says that.
that examination only in respect of the draft rule law. So far as the recommendation of the pay commission is concerned, that is binding for us as well as for the health
Who
department.
says it is binding?
It's a 309 rule law.
That's the rule.
No.
The recommendation of the pay commission.
Yes.
Recommendation of pay commission is not under three.
It's a rule law. That is why it is before the division bench.
And is there any the Assam nursing service rules of 2023? What does it say?
So there is no challenge as regard the service rule law. Challenge here, Lordship, recommendation of the pay commission.
Just find out and tell us on the next date whether. Let this matter come up for consideration on your date in October. It isn't. Find out and tell us.
After the puja holiday.
2018. 2018.
You have a very limited window,
Yes.
Ms. Bhuyan. Let's see.
Right.
Let's see how can it be resolved. All right.